15 minutes per side. Mr. Vader, did I say that correctly?
Vater.
Vater. Thank you, Mr. Vater. Are you prepared to proceed?
Yes.
How much time, if any, would you like for rebuttal?
I'd like to reserve 5 minutes for rebuttal.
All right, 5 minutes. When you're ready, please proceed.
May it please the court. My name is Michael Vater of the Ticton Law Group, and I'm here on behalf of the appellant, Invo Inc. There are 3 issues that are raised in the briefing, and I'd like to focus on the spoliation issue first, because that was the fundamental jury instruction which affected this particular case. In this particular case, there was a fire involving a bus on the compound of my client.
What happened to the bus?
The bus caught fire.
Well, no. What happened to cause it not to be available to be part of this trial?
Sure. So what happened was the representatives from the defense came on site, they inspected the bus, and then the bus sat for a period of 3, 4, 5, 6 weeks until in May of 2018, a few months later after the mid-March fire, the bus was then transferred to the insurance company who was representing my client. So the bus was sitting there for many weeks after this inspection occurred. Hundreds of photographs were taken of the bus, and that was very similar to what some of the sister appellate courts found, especially in the 2004 4th District Court of Appeal case, the Royal.
Well, Mr. Potter, let me just ask you this. Isn't the essence of the claim, the bus? So didn't you need that bus to make the claim?
We didn't need the bus to make the claim because the inspections had already occurred. Weeks had gone by before there had been any type of correspondence. No correspondence whatsoever had been received from the defense saying we need this bus to remain for additional testing, additional observation, additional review. The bus had remained on site for weeks. It was a burned out bus. It would have caused environmental issues, et cetera, if the bus had just remained there for months, years. How long is it supposed to remain on site indefinitely?
Well, no, and the court gets to ask the questions today, Mr. Vater. Thank you. But the question this judge has is, I'm just, again, having difficulty understanding how you advance a case on behalf of your client when the very essence of that case is the bus. And so here we know the bus was not part of the trial, correct?
Correct.
And at some point before the trial, it was destroyed?
The bus was not destroyed. The possession of it was simply transferred to the insurance company.
And so that was argued to the court?
It was argued and it was reflected. One of the great things is that this court has the benefit of the extensive orders that were entered by the trial court.
Well, and that wasn't the court's question. Is it reflected in the transcript that that argument was made to the court?
It's reflected in the order which reflected the testimony presented to the court, and that's where that argument was presented, Your Honor.
And after evaluating all of that, the court determined to give the instruction the court gave, correct?
It did.
But we do not have a transcript of that colloquy that led to the order?
No, we relied upon the order itself because our position is that the order accurately reflects what was argued and presented, what evidence was presented to the trial court.
So we're bound by the 4 corners of what the court said, correct?
Yes, we're bound by the findings of the court as well as the conclusions that were reached by the court.
So obviously you don't take exception with the findings of the court?
No, we don't take exception with the findings, but the findings of the court is what mandates the reversal because the actions in this particular case was not a situation of willful destroying of evidence to try to hinder the defendant in this case, nor was it a situation where someone was being negligent and spoiling evidence. It was simply a transfer of possession after weeks had gone by, over months had gone by before the bus had transferred to the insurance company. That was the first issue. The second issue that is the one that deals with...
Before we leave that question, This is a very specific fact question, and if you need to supplement later with a record site, that's fine. But you say on page 11 of your brief that the bus was only disposed of after the bus company received written permission from its insurance agent, who had obtained such permission directly from the repair shop. Okay, there's no record site to that, and I could not find, I did a word search, and there's not a single reference to permission among the 256 times it occurs in the record in connection with permission from the insurance agent. There's no reference to insurance agent that's relevant. Can you back that up? Did the insurance agent get permission from the repair company to dispose of the bus?
Yes, and I'll have to find where that is in the record.
That's fair. You feel free to file something on that. But.
How about a month and year that occurred, that apparently this permission, or I guess, what month and year was the bus sent to the insurance company?
It was sent in May of 2018.
All right, that was a year before suit was filed, the initial complaint was filed against Ring Power.
Yes.
So knowing there was a potential for an upcoming lawsuit to be filed, there was no burden on your part to preserve that critical evidence?
I did not see it because in the case law, in the Royal v. Alliance case, the Fourth District Court of Appeal in 2004 said there's no duty even when litigation is anticipated. So, and even the Second District Court of Appeal in Landry said that spoliation does not automatically lead to a sanction. There was nothing sanctionable that should have resulted as a result of the conduct.
Well, I think Judge Thomas's question is a little different. You knew, your client knew a lawsuit was coming, correct?
There could have been potentially a lawsuit if it was unable to be resolved between the parties, absolutely.
So given that dynamic, it seems to me that the court could reasonably find that knowing a lawsuit is coming and knowing the corpus of the lawsuit is the bus, that the fact that the bus is not there anymore is enough for at least some sort of presumption related to spoliation. Why is that wrong?
It's wrong, Your Honor, because of the fact that the critical issue was the defense had the opportunity to inspect the bus before it was disposed of, and they actually did come on site and dispose of the bus.
And I saw that, and you got their permission to get rid of it?
The permission was given from Ring Power's representative to my client's insurance representative to then my client to transfer the bus to the insurance company. It wasn't as though there was no evidence in the record to show that there had been a subsequent, after the inspection, some sort of efforts made by the defendant to come out and do further inspections or testing or photographing of the bus itself.
But you concede that inspection occurred almost a year before a complaint was filed, so they had no idea what causes of action were or were not going to be raised. So it's a blind inspection.
Well, the evidence in the record shows that that hundreds of photographs were taken. There was an inspection related to a fire on the bus, and that's what the record demonstrates. I would like to just briefly discuss a few of the other issues, one of which is the granting of summary judgment. It was improper for the court to grant summary judgment when there was an issue as to the credibility of the witnesses. The Vega case that was recent, that opinion, which was issued by the Third District Court of Appeal last year, really highlights that when there is a credibility issue.
Well, and this court understands, I think all three judges understand, credibility is not a summary judgment issue, but the only thing I see on the negligence issue is this email. And it candidly begs the question of whether it establishes a breach or causation. So explain to me how this email, even assuming it was admissible, and that's seems to me another hurdle you've got to overcome, but assuming it was admissible summary judgment evidence, how did this cryptic email establish a breach and causation?
The email establishes breach and causation because there's a reference in the email which says, based upon our conversation, the buses, et cetera, that specifically raises the issue of breach in terms of it being a potential issue in terms of the in terms of, in this particular case, a future fire or future situation. And that little email itself, it was what was being put forward.
I've got it in front of me, Mr. Votter. I don't see that, but maybe show it to me.
My particular showing of the email demonstrates that this particular item was argued here in terms of the bus itself.
Well, I'll just read it. Many of these issues would be a fire and/or safety hazard if left unfixed, correct? We definitely want to prevent any breakdowns or harm to any of our customers. Thanks. And then Ms. Ferber, Mike, yes, you are correct. I'm having trouble divining a breach of the standard of care and/or causation with this case from that one email. So where is it?
It's in referring to the review of the buses, and it was set up in our client's affidavit that he had taken the buses to this Mr. Ferber's shop in terms of the review, and this was his review after seeing the buses, and that was that breach and causation. I do just want to briefly...
If we don't find that, the summary judgment was proper, correct?
Well,
If we don't find as a panel that there was a breach and causation component to that email, then summary judgment was proper on the negligence claim, correct?
No, because of it has to be taken in connection with the affidavit of our client, which is in support. Just briefly on the last issue, it was the court awarded for a 5-page motion 23.7 hours of time, a 12-page motion 36 hours of time, an 18-page motion 58.8 hours of time as a sanction. And under the Martin v. Centex Rooney case and the order from the court which found that the plaintiff's expert witness testified that those amounts were excessive, it was improper as well for the court to enter that particular order awarding that amount of fees for the work that was done.
Counsel, what's the standard of review on that issue?
The standard of review is a de novo review because it was an
As far as
awarding of attorney's
reasonableness,
fees.
I mean, do we defer to the trial court's, expert-supported assessment, or?
To a certain extent, there is a deferral to the trial court, but there is also this, in terms of when there's clear duplication of efforts, as was reflected under the Tamano case from the 4th District Court of Appeal in 1993, it mandates a reversal. I see I'm into my rebuttal, so I'll pass.
All right.
Stop button at the top.
Promise I'm not touching it. Oh, the stop. Okay, thank you. There we go. How many lawyers does it take to figure out a podium? Good afternoon. May it please the court. My name is Jordan Janoski for the Appellee Ring Power Corporation. I'd like to begin with Judge Kelsey's point that was just asked. The standard of review on the fee award claim is abuse of discretion, and that's from the Philip Morris USA Incorporated versus Jordan case. It's cited in our brief. It's from this court from this year. So I won't elaborate too much on that.
And we don't have a transcript, right?
And we don't have the transcript, Your Honor. Again, this is all well within the trial court's discretion. I don't want to spend too much time on it, but nitpicking individual motions is frankly the trial court's job. And again, you don't have the motion or the transcript, and in any event, it's within the judge's discretion. So if there are no further questions on the sanctions, I'm going to go back to the summary judgment, if that's okay. So I think there was a line of questioning about this Ed Ferber email. And I agree with the court that that email by itself doesn't say anything. It needs context. And the context that should have come with that email is the affidavit, or are the affidavits of Invo's principals, Joey Friedman and Michael Farzad. Neither of those affidavits provide any further elaboration that give you context for what that email is talking about. So there's not only do we not have causation or breach of the standard of care, we don't even have a confirmation that that email is talking about these buses that we're talking about in this lawsuit. I mean, that's
We
how.
we don't have a timeline. Were they, I thought counsel indicated that they were after the accident, after the fire.
So I'm afraid I don't follow your question,
It-
Judge.
Was the email sent after the fire bus became the fire bus?
I believe it was, but my point is that the email itself doesn't reference any of these
Right.
buses, and the affidavits don't tie that email to these particular buses. So I guess, yes, it's theoretically possible that the email was sent after, the claims were raised, but there's nothing in this record tying Mr. Ferber's remarks to any particular bus that's at issue in this lawsuit. I can go further. We have the affidavit that Ring Power went and got from Mr. Ferber and used in its summary judgment evidence, in which he says, basically, that he doesn't know that Ring Power did anything wrong. He comes out and he squares that circle for us, right? He says, I'm not commenting on Ring Power's standard of care. So that's how we know for certain that Mr. Ferber can't create a summary judgment issue on the negligent repair case. So all the trial court has on summary judgment is Ring Power's expert shifting the burden, right? Saying that Ring Power did nothing wrong, there's no breach of the standard of care. And then we don't have anything from INVO in terms of standard of care to meet the now flipped or now the shifted burden. So I think Judge Jay, you're right on the issue. There's nothing in this record that creates a fact issue on the negligence claim. Excuse me.
We heard a lot of talk about spoliation.
Yeah, we can.
What says your client on the spoliation argument?
So, INVO's trying to relitigate factual issues that were decided below, right? The issue here, or the standard here, again, is abuse of discretion. And your honors are well aware the trial court's findings come clothed with a heavy presumption of correctness, right? That's the League of Women Voters case that's cited in our brief. Ring Power only needs to show that there's competent and substantial evidence to support the lower court's decision. And what the record here shows is that there's more than enough evidence to meet that task. INVO was told that the fire bus was evidence. That's from the order itself, which references Mr. Layson's testimony during the hearing, right? We don't have Mr. Layson's testimony in the record, but we have the judge's findings based on that record, and that's on page 3516 of the record. You'll see in the record somewhere that the bus was stamped, or not stamped, but had a taped with a placard saying, in big bold letters, evidence, right? This may be evidence. You need to contact the person, I don't know if it was Mr. Layson or someone else, who put it there, right on the side of the bus. So there's no dispute here that INVO knew that this bus was a piece of evidence. There's no dispute that it was important to this case, and INVO should have understood that it was important to this case. There's no dispute that INVO voluntarily disposed of the bus by allowing its insurance company to take it, basically.
Let me ask you a question about the bus versus the site where the accident occurred. I think there was some witness referred to the possibility that seeing it in place would have been important. Was it impractical to just leave it sitting beside the side of the road or wherever for a year until the complaint was filed?
My understanding is that the site was INVO's lot, for lack of a better word.
Is that in the record?
I don't know if it's in your record
Yeah,
that
I'm
that's an
fuzzy on what's
important
in there.
detail. What I will say is, today is the first I'm hearing of this suggestion that Ring Power as representatives authorized the bus to be disposed of. I'm not saying it didn't happen, but I have never heard that before. And so if there's going to be additional briefing, I'd certainly would like an opportunity to be heard on that issue. INVO disposed of the fire bus before it filed suit. It disposed of buses 1 and 2 before it raised its negligent repair claim. And so
What about their argument that you knew the vehicle identification numbers, you could find it somewhere and go look at it?
it's contradicted by the record in the lower court's findings, right? Judge Brasington said that the unrefuted evidence is that the buses are not available for Ring Power's experts to inspect after the suit. There's credible testimony in your record to support that finding, and so we're not in a position where we're litigating the entire case, right? We have Judge Brazington's findings, they're supported by the evidence, and so there's not a lot for this court to do on that issue. Counsel relies heavily on the Landry case. This is the odometer case where the car was repossessed. The biggest part of that case, or I guess there's two major components to that case that resulted in reversal. The first is that there was no evidentiary hearing before the sanctions were awarded, right? I think the sanction was actually dismissal of the case. And there was no finding, because there was no evidentiary hearing, that the evidence was unavailable to the defense. And this obviously is a completely different situation. We have two evidentiary hearings on the spoliation issue in this case, and we have the unrefuted testimony that the buses are unavailable, followed by the court's finding that the buses are unavailable. So Landry is not controlling or frankly even relevant in this case. The other component to Invo's argument is the suggestion that they didn't have a duty to preserve these buses, and that flatly is not what the case law says. The duty for litigants to preserve evidence triggers when a claim or litigation is reasonably foreseeable. That comes from League of Women Voters, which is cited in our brief, the Hediger case, which is cited in our brief, the Torres case that is cited in our brief. Frankly, I really don't think there's much dispute in the case law here. For a litigant, when litigation is foreseeable, that's when your duty is triggered. There's not, as far as I can tell, there doesn't seem to be a dispute that litigation was reasonably foreseeable to Invo. I don't think that on this record we could find a dispute there. So what we have are the cases that Invo cites, primarily the Royal and Sun Alliance case. And the distinguishing factor in that case is that that is a case about whether a third party has a duty to litigants to preserve evidence for them, right? In that case, a yacht caught fire after a repair company came in and did some work on it. Eventually, the subrogation insurer is suing the repair company, and they find out all the evidence is gone, and so they file a spoliation cause of action against the marina that held the property. And so the question was whether that marina owes the litigants a duty. I think in that case, the Fourth DCA found that there wasn't a duty. But the point is that that's a different question than what we have here about what duties litigants owe each other to preserve evidence. Counsel cite the Martino versus Walmart case, another Fourth DCA case. The issue in that case is a kind of a nuanced and tricky one, but also not relevant here. It's whether you can maintain a separate spoliation cause of action against your direct tortfeasor in addition to your negligence claim against them. So in that case, I think it was a shopping cart that was allegedly negligently maintained or repaired that injured a personal injury claimant, and he wanted to sue Walmart for the personal injury, the negligence, right, negligent maintenance of the cart, but he also wanted to sue them for spoliating the cart and getting rid of it. And so the Fourth DCA expressly sidestepped the issue of duty in that case. They say whether you have a duty to preserve in this circumstance or not, you don't have this cause of action. So again, I'm taking us kind of far afield because that's the case law that Invo is relying on. It's not on all fours with our facts here. We have a straightforward negligent or a spoliation claim here of a opposing party that has spoliated the key piece of evidence in the lawsuit. There are some other issues that are touched on in the briefing that I'd like to make sure I cover with my time. There's some suggestion that the court's various orders create some sort of risk of a double recovery. I just want to emphasize that I agree with counsel that a double recovery is not permitted under our law, but the orders that we have in this case are carefully worded to avoid that exact possibility. We expressly, our office drafted the orders. We made sure that this wasn't going to occur. We would never seek to have a double recovery in this case. It's just not a risk on these orders. And then the other issue I wanted to address briefly is the FMVRA summary judgment. I just want to emphasize again that counsel, or Invo, excuse me, is attempting to rely on evidence that was not presented to the trial court on summary judgment. Right? We have this rule, again, bear in mind we're under the old rule. This was decided before the switch last year of the summary judgment rule. Under Rule 1.510C, a party is required to identify their summary judgment evidence with specificity, what they're going to rely on at the hearing on the summary judgment. Invo did that. They provided the 4 affidavits that they relied on. That was their summary judgment evidence. They didn't cite to anything else. They didn't rely on anything else. That was their summary judgment evidence. When Invo lost on the FMVRA issue, they wanted to come back. They asked for reconsideration, and on reconsideration, they pointed to additional pieces of evidence that they had not relied on, but which were available to them on summary judgment. They wanted to get a second bite at the apple. And there's plenty of case law, there's the rule itself, say you can't do that. Okay, so you can't point to these other documents and say, these create a summary judgment issue. And of course, those same.
Counsel, let me ask you a question about the statutory claim.
Sure.
It appeared from my review of the evidence that they were happy to, pay the invoices, even if there wasn't a written estimate or it went over a little bit. I mean, I do it. Is there a requirement under the statute that there be some sort of actual injury that they,
Damages are certainly a component of the statute. It's not as simple like you failed to give me an estimate, therefore pay, $100 or whatever. It's, you have to, if you've been damaged by a breach of the statute, then you have a civil cause of action. But I would say more importantly, we have the same issue with the 5 invoices that are identified in the briefing that we have with the Ed Ferber email from the negligence issue is these documents by themselves don't show a breach of the statute. They need context. They need someone saying, this is an invoice that I received that I don't have a corresponding written estimate for, and that's not in your record, right? And in fact, we have at least one of them. We have the pro forma invoice, the written estimate, in the record. The others, I don't know whether we have the pro formas for those in the record or not, but the point is, the burden is on the plaintiff to show what these actually mean, because by themselves, they don't show a violation of the statute. And in fact, there's nothing in your record that shows a violation of the statute, and that's why summary judgment was granted, and that's frankly why the summary judgment should be affirmed, as should the other orders that are on appeal. And so if there are no further questions, I think that would be the end of my time. Thank you.
Rebuttal?
Thank you. I'd like to address a couple of the points that have been raised during the appellee's presentation. One, the statute under the Florida Motor Vehicle Repair Act states that the actual damage is the having to pay that invoice that was not, for which a written estimate was not provided. So there was no requirement to show additional injury or loss besides the having to pay that invoice that was presented in the affidavit itself, and that also came from the 5th District Court of Appeal case Austin versus Morris from 1986. There's also the email for Mr. Ferber the record shows was sent after the original fire bus. And the record also shows that there were only 3 buses that Invo had that owned. They only owned 3 buses. There was the 1 bus that caught fire, and there were the 2 other buses, which were subsequently examined by Mr. Ferber after the fire situation. That his email placed in context with the affidavits that were set forth did present sufficient record evidence under both the old standard of 1.510 as well as the revised standard of 1.510 to present a question to the jury where a jury could reasonably find in favor of the claim. So we would ask that this court reverse the order vacating or reverse the order entering final judgment as to those claims to allow those claims to be presented to the jury. And then the fundamental issue comes up in terms of the spoliation issue. And the facts are not refuted because the court put the facts are properly placed in the order by Judge Brasington, which was that there was testimony presented at the evidentiary hearing by INVO's representative. There was testimony presented by Ring Power at the hearing. Here was the testimony. And the testimony really isn't so much in dispute in that there was a bus that caught fire. The inspectors came out within a few days later. There was an extensive multi-hour inspection related to the vehicle. And then ultimately the vehicle was transferred possession from INVO's lot. I think there was a question asked as to where it was located. It was on a lot that was, it wasn't along the road because the fire had actually happened while fortunately no passengers were on it. So ultimately we would ask this court to reverse the orders and remand for a new trial as to all counts in this particular case. Thank you for the court's time and opportunity to present today.
Thank you, counsel. We are in recess.
All rise.